Assalamualaikum. My name is Nur Hidayah binti Kamal Zaman, metric number 273343. I am from Group Titans. As you can see on the slide here, they are all my group members. So, I will start the presentation with question 1 for the first issue, which is Tubuh Energi Sendirian Berhad TESB would like to have 57 shareholders. TESB is a private company since there is a term of Sendirian Berhad at the end of its company name. As a legal advisor, I would like to advise TESB to convert their company from a private to a public company in order to make sure that they are able to have 57 shareholders. This is because according to Section 42 Subsection 1 Company Acts 2016, it is clearly stated that shareholders are restricted to 50 people for a private company. However, there are no limitation for the shareholders in a public company. Therefore, TESB need to convert to a public company by following the procedures under Section 41 Subsection 2 Company Acts 2016 in order to make sure that they are able to have 57 shareholders. Based on Section 41 Subsection 2 Company Acts 2016, a private company may convert to a public company by a special resolution and shall lodge with the registrar certain documents which are: first, a notice for conversion and specifying an appropriate alteration to its name. Second, a statement in lieu of prospectus. And the last one is a statutory declaration where we find that paragraph 190 subsection 2 subsection B has been complied with. To sum up, Tubuh Energi Sendirian Berhad can have 57 shareholders only if they convert their company from a private company to a public company by following the procedures under Section 41 Subsection 2 Company Acts 2016 that I have mentioned earlier. I think that's all from me. Thank you.
So now I will present question 1, Roman 1. So let me introduce myself first. My name is Syaratul Amirah binti Muhammad, with metric number 272958. So from the above case of Mr. Razi and Company X, the main issue is it possible for the Company X to refuse to surrender anything to Kelim Berhad? So according to the Section 20A of the Companies Act 2016, the company incorporated under the Act is a body corporate and must have a legal entity distinct from of its member. So in the principle of the separate entity, the company and member are two distinct entities. So the related case is Salomon versus S. Salomon and Co. Limited at 1997, where the Salomon transferred his sole proprietorship goods manufacturing business into a company, Salomon Limited, incorporated with members of himself and his family. Salomon received share and debenture with a floating charge debt security on the company's asset. When the company were bankrupt and to be liquidated, Salomon right of recovery secured by floating charge over the debenture trumped the claims of unsecured creditors who would have received nothing from the process of liquidator. So the liquidator tried to ignore Salomon Limited's different personality from its member Salomon in order to hold Salomon personally liable for the company's debt. Thus, the court decision is Salomon must indemnify the company because the company acts as a Salomon agent. So the Salomon must indemnify the corporation. The appeal court also has determined because the company serve as a trustee for the Salomon. Next, for the application is based on the Section 20A of the Company Act 2016, Mr. Razi must have take responsibility for all his wrongdoing action as he was involved in secret profit making while he was a sole shareholder as well as he was be a director of the Company X. Thus, because Company S is distinct from the Mr. Razi as an individual, Company X may refuse to give anything to KB on the ground that Company X was unaware to Mr. Razi's action as well as they are in the two different separate entities. As such, Company X was not involved in this matter at all. So the KB should not take any legal action against the Company X but must toward Mr. Razi. So in conclusion, due to the fact that Mr. Razi and company are two different separate entity. Company X has a right to refuse to give anything to Kelim Berhad.
Assalamualaikum. My name is Nur Ayuni binti Abdurrahman. My matric number is 273353. Now I will be in charge to explain the pre-incorporation contract. So we have an issue with whether a pre-incorporation contract binds a newly incorporated company. First, we need to know what a pre-incorporation contract is. It is referred to a contract that purports to be entered into on behalf of a company that does not exist. But the legal position of the pre-incorporation contract under the Common Law and Companies Act 2016 is different. Under Common Law, pre-incorporation contract do not bind the company before its incorporation, and the company cannot ratify the contract. The promoters act as an agent for the company is personally liable for the pre-incorporation contract. We take Kellner versus Baxter case as an example. In this case, a group of promoters enter into a contract on behalf of the unformed company to purchase wine for a new hotel business. Then the company was registered and the wine was consumed. Unfortunately, the company went into liquidation and failed to pay for that wine to Mr. Kellner. So he has brought an action against the promoters that act as the agent of the company. The court stated that promoters were personally liable for the pre-incorporation contract made before the company yet to be incorporated because they are the consenting party of the contract. That's all from me. I will pass to the next presenter, so thank you.
Hi and Assalamualaikum. My name is Sharifah Khadijah binti Said Muhammad Abdul Wahab, matric number 272955, and I will continue the presentation from Nur Ayuni. On my presentation, first we will focus on Section 65, Subsection 1, Companies Act 2016. This section states that the person who signs the pre-incorporation contract will be personally liable for the contract or transaction. Meanwhile, in Section 65, Subsection 2, Companies Act 2016, permits the company to ratify the contract after incorporation. The company will be bound by the contract as if it existed at the time of the contract or transaction. We take Cosmic Insurance Corporation Limited versus Hu Chiang-Pu case as an example. Okay, this case about Mr. Hu was appointed as the managing director and entered into the pre-incorporation contract, which a group of promoters of the company. Once ratified, his appointment has been slightly different from the previous appointment as he had been fired from the position. The court held that the ratification of the pre-incorporation contract did not affect the appointment of Mr. Hu as director. Next, according to Section 65, Subsection 2 of Companies Act 2016, a newly incorporated company can be bound to a pre-incorporation contract. Any contract that entered into by a company or person in behalf of a company before its formation can ratify the contract after being incorporated. So, the company may be bound by the contract as if it existed at the time of the contract or transaction. So, the conclusion for this question, the newly incorporated company can be bound to a pre-incorporation contract according to the Companies Act 2016. That's all from me and our group. Thank you.